The slow pace of court cases in Nigeria has been abused by many who institute frivolous cases to achieve their aims. Recently, the courts have been issuing heavy fines against litigants and their lawyers for instituting what the judges called frivolous cases. For example, the Federal High Court fined the residents of FCT seeking an injunction against the inauguration of President Tinubu 40 million naira. The question, however, is whether these stiff penalties against litigants and their lawyers serve the interest of justice. Will these drastic sanctions inhibit access to justice and undermine public interest in litigation? Well, there's one man here that is going to answer the myriad of questions arising from that. And we're joined now by Arise analyst, Associate Professor of Law, Sam Amadi. Thanks very much. You've asked, I mean, it's a myriad of questions there. Is it going to discourage litigants and how about the lawyers? I mean, we know some lawyers ill-prepared, you know, any matter, they just say, we'll go to court. Let's meet to court. It's now become, you know, a big slang in Nigeria now. So
go to court.
Yeah, go to court, you understand. But, I mean, looking at the truism, I've heard a judge who is now at the appellate court said in New York, you don't approach the bench with frivolous cases. It's a process of debarring you from practicing as a lawyer. When you know a case is bad, it is bad. So advise your client and save the court the time. Should that be the case in Nigeria?
Well, I think first is to put it in context. I mean, you're right about maybe the specter of frivolous cases. And again, when you have too many cases, like we talk about election cases, we talk about judicializing politics. It's always the outcome of sloppy administrative law proceedings. Take, for example, INEC. They say go to court. Some of the things courts are dealing with are things that INEC should have done in administrative adjudication. So we shouldn't let off institutions and their malfunction. The second point is judges don't owe you to hear your case. And I've been making this point for over 10, 15 years, that the judges should have control of their proceeding. You know, you see some many cases, Supreme Court takes a case for 7, 8 years, and in the judgment they will write, this case shouldn't have come, but you kept it in the docket. So many jurisdictions, the courts have a way of going through their dockets and clearing matters. So some cases, they see it as not triable, they're not going to handle it. I think over the years, we built this system in our legal jurisprudence that says all matters, the courts have to hear them. If the court does not hear you openly for everything, people say it's a violation of human rights or fair hearing. But the key point in these big sanctions is that they have a chilling effect on litigation. There's a public interest for lawyers and people who may not be directly concerned to take up issues. For example, Chichi Rodenkale, a professor of law, recently took MFL's tenure to court to ask for some questions, which the court says you have no locus. So the narrow reason of locus, for example, since Adesanya against Senate, the President of the Senate in the 1980s, judges say struggle with the idea of what they call public interest. They said, look, we should allow citizens who feel aggrieved to come up, because if you're waiting for those who have the responsibility, they may not. So the Supreme Court has moved on to say, look, people should be allowed, persons who are reasonable professionals or who have sufficient interest to go to court. What these things are doing now is that it might create a perverse incentive for people not to approach the court for public interest. And the Constitution allows, in fact, the Constitution depends on public interested lawyering. Over time, under the military, Ghana with me, we know many cases were filed. So the question then is, if military dictatorship will allow, if courts under military dictatorship gave status, gave standing, sometimes they will dismiss the case for insufficient interest, but they never penalized lawyers. If under military rule, they allowed public interest. Under democracy, now we're witnessing the reverse, where judges are angry, maybe because lawyers have been criticizing them a lot. So I think that there should be a balance. Are
they fighting back?
I think there's a fight back, because you give people 40 million for going to court. Now, if they go to court frivolously, you dismiss it. if their conduct...
It does not warrant a fine.
No, if the see what happens, if your conduct in going to a court is reckless, provocative, they can do a citation against you for debarment.
Yeah.
Now, debarment shows that you acted unprofessionally. But somebody can act professionally with good intention, but the court takes a view that we're not going to give you access. That is a legal argument. So that shouldn't warrant damnifying the person in sanction, because what that does is a chilling effect. And again, because, like Oputa observed, in fact, the Indian Supreme Court says epistolary. You can even write a letter. They talk about the directive principle of state, that it should ground judicial intervention to protect the common people. So the point I'm making is that, look, we need to walk a tight balance here. First is, we don't want frivolous cases. The court should have the jurisdiction to strike you out and say, you know what, we bar the door against you. You can do nothing. The first day, they look at the case and say, this case is throw it away. The court, the Constitution gives them the power to do so. But if they hear you and take the view that you don't have locus, and take the view that your case is not judicially manageable,
frivolous, yes.
Judicially manageable, I mean, then they have to dismiss you and say, go away. Damning them in court has the effect of now freezing legal activism. And for a democracy that's trying to consolidate, it's also in public interest that people don't go to violence to go to court. When people go to court, it's a constitutional behavior. It shows that they recognize the authority.
Seeking, justice.
They may be they may have misconceived their case. They may not have the proper knowledge about the process. Yeah. But if you discipline them in this harsh way, you are now telling them you had better resort to violence because the court is shut down. So my word as a legal practitioner, the first lawyer in Nigeria, Sapara Williams, says the lawyer lives for the development of his country. Public interest litigation is very critical to democracy. Even the US, look at Trump, for example. Over something cases were filed, each dismissed by different federal courts. Still, they were still going. Supreme Court knocked them off. Nobody, look at the people they cited. They cited Rudy Guyana and the other woman because they lied. Two, so they acted misconduct, which now triggers debarment proceeding as well as criminal proceeding. But the fact that they took cases that many people consider frivolous to court didn't result in any damnification, because that's really for the court to say, my friend, get out of the way. You are not qualified to be here. So my worry is that it's actually in public interest to keep the door of the court wider so that people can come in. But to have a mechanism that controls proceedings so that if you come in, even ex parte, even in chamber, they can remove that case and this is not a proper case. And that will discourage people from coming to the court, if they have no case. But if you now put people in peril, they will not likely go to court except they are 100% that the president backs them up, in which case it's narrow.
But you see, the lawyer has a critical role here to play. In, deciphering, do you have a case? Before I go to court, I come to chamber and I discuss my matter with you. You'd be able to say, with your years of experience at the bar, to say, look, you don't have a case here. These are the reasons why you don't have a case here.
But what the professional rules tell a lawyer is that you should take every case that's within your area of practice. That's number one. Number two, it also tells you that the law is what the court says it is. So people say, okay, this looks like this. But wait a minute, we want to make a case that the court should do it that way. I am in support of closing down on frivolous case, and I said two instruments they're not using well. The chief judges of the court should make rules that authorize judges in chamber to review cases and pass first certification.
Not necessarily in the open court. Not always in the open court.
There are some cases the judge should certify and say this case can't come up because it really does not make sense. Now, we can trust the judges to make that decision. Those that abuse it have a process for controlling them. But we shouldn't be too open to damnify, sledgehammering 40 million. Now, let's take, for example, the case of the indigens, okay? It may be totally misconceived, but these are people who said, look, we are native Abuja. There's a contention that 25%, even the lawyers, senior advocates are going to canvass that case.
But was that court the appropriate court to adjudicate on that matter? It's election matter.
That's the point. Let me give you an example. I have a case in the court now where I'm seeking for issue against INEC. They say it is it's not election. It's judicial review process. You see, the mistake we have made is that we have lumped everything about election as if it's a petition. Election petition is only what somebody who either is contesting that they ought to have been declared, it should have been a candidate, and others. But somebody can say, look, I'm not satisfied with the conduct of this election, but I'm not interested in the outcome. I'm not challenging any outcome. My interest is to say somebody didn't follow the rules. Let that person be interrogated or punished. That's not a petition. That's not an election case. That is a judicial review process. Now, the point I'm making, I may be wrong, you may be right, but those kind of behavior does not come to the level of totally unprofessional. It could be unreasonable. I mean, I can tell myself, look, I don't think I should go to this court. And the court should, again, in many of the Supreme Court before, they will use verbal, they say, this lawyer, this disgraceful misconduct. So you name and shame, and then it goes into his profile. People say, oh, this is really, just like they said in the case of Kiyamo. Okay, the judge says, maybe, some uncomplimentary words.
Yeah.
I mean, this is not advocate. But it does not in any way constitute, people shrug it off. I mean, judges can abuse you, just like...
Well, was slammed with 10 million naira.
Kiyamo?
Yeah.
For the case. I'm saying those are not good, because you see, 10 million in today's currency, it's actually very big. I mean, Kiyamo can pay as an advocate, okay? As a former minister, rich enough. But think about the anti-corruption guy who means well, but who probably misses his road in the judicial corridor because he didn't pay attention to a particular issue.
I like that. He missed his road in the judicial corridor.
So you can come to us and say, my friend, this is not the proper procedure.
Yes, and not to slam that every fine. Yeah.
I mean, so because public interest means that we should allow more of cases, even though some will be frivolous.
Ventilation of cases.
Exactly. And then it helps to control conflict, result to violence. So I think that's really the way to look at it.
Yes, thanks so very much. I won't go and, loiter around the judicial corridor.
So you don't miss your way.
I don't miss my way. Thanks, Dr. Sam Amadi, Arise analyst and associate professor.